Hey y'all, it's me. It's your girl, the real deal, Anita's Gills Reaction Channel. Yeah. Like, share, and subscribe. What's up, real deal? Good morning, evening, noon, night, wherever you from. And thanks for being here. Oh, yes. Come on, y'all. We got to get them lights up, real deal. I'm doing hard work over here. You can tell. Go to my net. Hey, it's growing. I'm growing the channel, and I got some more good stuff coming out and get people to do certain things for me, okay? So I can just focus on the content, okay? Where I'm good at. All right, DJ, kill the music for me. Thank you. All right, y'all. Content today is going to be about my boy, Young Thug. Yes, Young Thug. Young Thug renewed case for bond, set the record straight. That's what we're going to talk about today. Young Thug renewed case for bond, set the record straight. Oh, renewal. What the real deal talk about renewal? What is he trying to renew? He trying to renew his bond. Yes. Okay. Let's see if anything good happen with that. Now, in order to renew his bond, he got to have a lawyer, and things have to go and play with this, with trying to get a bond. You don't just walk up there and get no bond like that. And another thing, this case been a moving case, so whew. So anyway, we'll have to see what the judge say. It's gonna be up to the judge, okay? Regardless of what Young Thug is going through medically and mentally. That bond, when you ready to set that bond, it's a lot. He just got locked up last year, so he haven't even did 5 years yet. So let's see what happened. He probably got bond. Let's see. Let's check it out.
Good morning, Your Honor, Madam Prosecutors, Mr. Prosecutor, all the lawyers here on behalf of the other people, on behalf of Mr. Jeffrey Williams, Mr. Adams and I would like the court to reconsider its denial on 2 previous occasions of bail. We filed this motion on April 24th, 2023, and we allege that Mr. Williams has been in custody since May 9, 2022. It's the date of his arrest. As the court previously heard, and if you need me to go over it, I will, but I'm assuming that this honorable court remembers the previous bond hearings and all the witnesses and exhibits that we placed before the court.
I do, sir.
I assumed you did. Mr. Williams, as you know and remember, did not flee when law enforcement officers came to his home on May 9th, 2022. He came out of his house. He called me, actually, and then came out of his house and was not in any way anything but compliant. It's now been more than 14 months so far. As the court may know and remember, the only potential nutritional foods consumed by Mr. Williams since May 9, 2022 include carrots, rice, lettuce, beans, and hot dogs.
Do hair relaxers cause cancer in women?
I'm sorry.
Beauty product manufacturers may have put millions of women at risk. Recent studies suggest a possible link between hair relaxers and certain forms of cancer.
The beans and the hot dogs, y'all. Cause I like beans and hot dogs. Okay, so I ain't laughing at that, but it's just the way the lawyer talking, y'all. I'm sorry. It's just the way the lawyer talking about beans and hot dogs. Let me take that back a little bit. Look, like that gonna make him feel sorry.
I'm not anything but compliant. It's now been more than 14 months so far. As the court may know and remember, the only potential nutritional foods consumed by Mr. Williams since May 9, 2022 include carrots, rice, lettuce, beans, and hot dogs. He mostly consumes products which have absolutely no nutritional benefits, which are M&Ms, chips, other processed or artificial bagged chemical substances. The lights, as the court may remember, in the small, isolated, solitary cell that Mr. Williams is housed in an off-site county, the lights are always on. They are brighter than the lights in this courtroom. So sleeping with bright lights in his face all the time, if he can get to sleep, and that is a form of torture which is not compatible with necessary restoration, sleep, restorative sleep required for Mr. Williams, who is a person on trial and needs to assist his counsel. Your Honor, this lifestyle for the past 14 plus months has caused physical harm to Mr. Williams. As the court recalls, he was taken to the hospital. If the court does not know, and Mr. Williams gave me permission, it is for his kidneys. Mr. Williams was raised in total poverty. He is used to not seeking medical help because he could not afford saying when he was injured or hurt. But he comes in this courtroom every day, writhing from pain from his kidneys. The kidneys removes the waste and extra water from the blood, evacuates through the body, through urine to maintain balances of the body's substantive fluids, to keep proper balance and levels of potassium, calcium, and sodium. The diet consumed by Mr. Williams endangers his health. Pretrial incarceration, Your Honor, is not supposed to damage a person's mind, spirit, or body. It is not for punishment. And this physical incarceration for such a long period of time, and the trial is estimated to last 6 to 9 months, and that's a considerable amount of time. The court has always said, I will put you on trial right away. I'm very aware that I denied bond to your client, and we appreciate that. We filed demand for speedy trial statutorily and constitutionally. But it is still a long time. As the court may notice, takes note of Mr. Williams, he has gained tremendous weight. If he's weighed now compared to the time he weighed on May 9th, you will see how much weight he has gained. He does not fit into his clothing anymore. He has all new clothing, and this is a problem caused by the kidneys and the lack of nutrition and exercise. Your Honor, the support for the community is still here with Mr. Williams. It remains here, as I previously showed this honorable court, to a packed courtroom.
Rebag, a luxury resale marketplace, curated with an
His family is all from this area. They love him and devoted to him. I speak with them weekly, if not more. His friends have stayed with him. Co-workers of Mr. Williams in the music industry. One is a gentleman who is on your screen in courtroom 8H, as in happy. His name is Jeff, which is Geoff, Ogunlesi, Ogunlesi. He has flown across our country to be here today when he found out that this honorable court set the hearing on Tuesday. He is in, if you need him, he is in courtroom 8H, and he will speak to the court if needed. There are professionals of the highest, officers of publicly traded company, the record label, that are on your Zoom. Mr. Kevin Liles, Liles, and he authorized me to tell you that he again embraced in total his previous sworn live testimony before this honorable court, and he stands by it with all of his power and might, and is willing to answer any of your questions that you would have of the prosecution for bond for Mr. Williams. Within this past month, Your Honor, Mr. Williams released a record. It was
Now, I'm going to object to this proffer or opening or this portion of it as irrelevant to a bond hearing.
I can answer that if I need to. It goes to his.
But look, y'all, what do this bond hearing got to do with him making a record, y'all? He made a record while he in jail. You can do everything while you're in jail now, can't you?
His employment and his steadiness, employment in the industry and in this trial at this time. He has still maintained total employment and he's still active.
Okay, all right, I'll allow it.
He is that record, Your Honor, became the #1 rap record in
Objection, Your Honor, having finished my objection to as to
What's the basis? Relevance? I'm gonna overrule the objection this time. All right.
Is the #1 rap record.
Let's move on, Mr. Steele. I understand it. You've convinced me that he's employable. So.
Well, I think the court should know it's also #2 record in any field. And I think that that's important for the court to realize there's no risk of violating condition of bond. This gentleman is an accomplished superstar in music. And I think that should weigh heavily that he would not jeopardize that by violating any condition of bond. Your Honor, America's justice system is built on the presumption that bail should be granted if there are any conditions that can be factored to ensure that the community is safe, the person does not pose a danger to the community, witnesses will not be intimidated, there will be no obstruction of justice, the person will not, in this case, Mr. Williams, will not commit a felony or any crime, it says felony, but any crime while out on bond, and that Mr. Williams will appear in court. Because if we do it the other way and maintain people and house people and warehouse them as Mr. Williams had.
Yeah, look, this supposed to be a bond hearing. I know he want him to know that if he rap, he's gonna do what he's supposed to do because he'll be rapping, but he needs to get more important into the reason why else he got to get a bond, to take care of his child. Come on, this him not making it. Come on, throw it at the judge a little better than just the rap poet. You don't want to hear nothing about the rap poet.
Has been, then the presumption of innocence, which is our entire standard in Georgia, is gone because he's being presumed to be guilty. Your Honor.
He got to do better than that. I see why they denied the bond because he trying to make the. I know you supposed to make the judge a little stronger, to try to convince him that he'll do the money. He should have said something about he would do the ankle monitor to to go back and forth to work. He ain't said that yet.
Georgia, unlike some states, for purposes of pretrial bond, the presumption of innocence remains with Mr. Williams accused of any offense, even a capital offense, which Mr. Williams is not charged with a capital offense, from arrest and even during trial. That's Vanderford, Vanderford versus Brand, Brand. It's 126 Georgia, 67 and 70, 1906. That means, Your Honor, that prior to trial, this honorable court must view Mr. Williams to be innocent.
I do. We don't look. I understand that you're trying to meet your burden in the sense of for the four factors.
Listen to the judge, y'all. He sound like me. He said what I just said. Get to the point about trying to get him a bond, but you ain't talking about the money. You ain't talking about all that. You talking about like this. This is a closing argument.
Under our law. So I'm going to assume that, I take into account the prior testimony that you've given in this particular case. Is there anything that you want, other than the updated issues as to his record release recently and employability? Is there anything else you want to augment that with?
Yes.
And then I'll let the state respond and, present anything they may have to the contrary.
Yes.
Okay.
I have seen, and I've been here for every bond hearing except one, Mr. Miles Farley. I was not present for that. I've seen this honorable court deny every person's bond who's in this indictment. But then 7 months later, approximately, I saw the state who called all these people that they are danger to community. They cannot fashion this honorable court cannot fashion any conditions of bond that would permit bond to be granted. And then 7 months later, the prosecution for 8 co-indictees offered, and this court accepted, negotiated pleas of time served. I can't wrap that around my mind.
What does that have to do with your case and your bond? I mean, each individual defendant is on his or her, in this case, their own merit. So why does that have anything to do with you?
Because I don't believe that the
Your client, I should say.
It's fine with saying me, but
it's not about you. It's about Young Thug, baby. See, y'all doing too much.
I don't believe that the proffers you're getting from the state are accurate. They have been proven to be inaccurate. I heard Mr.
Unfortunately, that's the way the law goes at this point in time, and our legislature hasn't addressed that. I mean, you've asked me to take a look at that. It's a different standard when we, pre-trial as opposed to when we're in trial. So, I mean, I understand that. I know you'll probably review that at some point in time, but at this point, I'm stuck with what I'm stuck with in terms of the legal posture of what the Constitution and the case law allows me to do.
There is no case that says that there's a difference between pre-trial and in-trial. That is not accurate.
In terms of the standard for motions and requirement for witnesses and live witnesses, should there be?
I misunderstood. I thought you were talking about bond law.
No.
Okay.
No, sir.
But you did grant bond. I was not present, but you did grant bond for Mr. Miles Farley. And there has to be a way that
on the individual circumstances of Mr. Farley. Mr. Williams I have to judge it on his particular circumstance.
Yes, listen to the judge. It's about him. It's about Young Thug, not you, baby. It's about the Young Thug. He don't care nothing about your feelings. He put the case back on Young Thug. Try to get Young Thug out of it. I see why he didn't get out.
Yes.
I'm judging on Mr. Williams. I think Mr. Williams is more than bond eligible. Your Honor, we still have.
You done got on my nerve. Whew, yeah, I got to be. I'm just get to the business. That's all I am. I'm like, get to the business, get to the process. Let's do it.
Officers willing to supervise and surround a home that will have no electronics and no visitors. There will be no computer, no cell phone, and law enforcement officers outside of the house. We will pay for transportation to and from the courthouse. Otherwise, with an ankle monitor on his person, he does not leave that home. Mr. Adams and I and our other co-workers would request to meet.
Now he talking about the ankle brace monitor and all that kind of stuff. You still should have came out with that. These lawyers not good like they used to be. Allegedly.
Mr. Williams inside that home on weekends and at nights. But other than us, nobody comes in. We can leave our electronics outside and bring paper copies because that's what I do at the outside jail anyway with Mr. Williams. Now, sometimes they do let me come in with my iPad to share discovery with Mr. Williams. I have to ask special permission, and I can do that through the court. But Your Honor, that is a factor that should be considered by the honorable court, that Mr. Williams can live at a location that can be vetted by the honorable court and law enforcement and the district attorney's office. I've gone further. not only with local police officers, if you don't like local police officers, I'm not saying anything wrong, but for whatever reason, that is not sufficient. There is a former Secret Service agent, there is a former U.S. Marshal that would take the responsibility of securing and transporting Mr. Williams in a home by himself and following every condition of bond, which we would ask for at this point, no visitors except legal and not to leave the house.
Except don't want to see his child. No, he don't want to see his child. Come on, man, that man got children. Tell the truth.
Got to go to a hospital and on an ankle monitor. Your Honor, liberty is the norm in our community. And this custodial detention prior to trial, when there are conditions that can be fashioned, is against our law. I will answer any of your questions. Mr. Ogunlesi will answer your questions, but he is Mr. Williams' manager. He will answer any questions, but he is behind Mr. Williams 100%, and Mr. Kevin Lyles is with the record label, and he also is with Mr. Williams, and as I said, he incorporates, or I incorporate his prior testimony. Your Honor, I want to answer any of your questions. I want to thank you always, but this is a big case with a lot of discovery. We got discovery yesterday evening. I go through with Mr. Williams. I'm with him every day. I'm in court with him. I'm on a Zoom call with him, privileged Zoom call at the jail, or I'm with him at the jail. It is a lot better for us if he can stay awake, if he can participate and assist. And there are conditions that we have because he has the resources. That doesn't mean a resource to flee, like you heard, he can rent a plane.
Okay. Ooh, child, they got a whole lot to go through, y'all, in these trials, honey. Y'all need to stay out of trouble. Good late. But I do want y'all to know his bond was denied. Real deal, y'all tell me what y'all think. Like, share, and subscribe. I'm out.